My name is David Greene. I'm senior partner at Edwin Co. And I and my team have been working with litigation funders for many years. And I want to talk about litigation funding and introduce you to it, the what, the why, and the how. So I'm going to start with the what. What is litigation funding? Well, it is investors willing to take a risk by investing in a piece of litigation on the basis that they will share in the proceeds. This has grown over the years, and it's certainly an alternative investment, but we are seeing a greater interest in litigation funding, and it has grown enormously in the last 5 years. Why would you want litigation funding? Well, the answer is that you may have a piece of litigation, or you may, with others, have litigation with substantial possible proceeds, and you want to avoid the risk and the cost of the process. And there's no doubt that litigation is risky. You are ultimately dependent on one person, the judge, deciding in your favour. And it's also costly. Lawyers' costs, as we know, are high, but also all the subsidiary costs to a piece of litigation are extremely high. And you want to try and avoid that with litigation funding. There's no doubt that the litigation process is expensive, particularly if you see it right the way through to trial. Most cases actually settle, but at the end of the day, you do take the risk that the case will go to trial, and that will be an expensive process. And it's not just lawyers that are expensive, but it's all the associated costs that go with it. For instance, experts may be necessary for a case. Litigation funding is a form of finance, but it is expensive. You'll find there are many other ways to fund litigation that might be cheaper, like taking a loan. But the great thing about litigation funding is it's removing that expense and the cost, and it is completely contingent on the outcome of the case, either through trial or by settlement. And that's a great thing for claimants to have. You have a claim, you may have a claim with others, you've been to lawyers, you've been to barristers, and they've told you that they share your confidence in the outcome of the case. And you want to start proceedings. And your lawyers are going to discuss with you the possibility that you might finance the case with litigation finance through third-party funders. Now, many solicitors will be familiar with the market, but many won't. And it's quite important to have some familiarity because your lawyers will be able to introduce you to third-party funders, or you might go through a broker. There are some brokers who provide a really good service in relation to finding that finance. You have to set out the case effectively as an investment document, because that's what the litigation financier is doing. They're investing in it, and they need to be persuaded of a number of factors. Oddly, the law is not the most important for them. The most important is the defendant going to be good for the money at the end of the day? Because even if you win and have a piece of paper that is a judgment, if you can't enforce it, it's of no benefit to a financier. They need to know that the defendant is good for the money. They may then want to say, how about the law? Is this a good case? And you've got lawyers who are advising you that you have confidence in the case and it's going to come to trial and you're going to win it. Now, those two factors need to be set out in a document presented as an investment document to the financiers, and they will make a decision. Now, at the moment, a claim has to be of substantial worth in order to make it viable for litigation funders, because it is a costly process. And let's just look at the likely costs of the finance. Let's say you're borrowing £1 million in order to run a case. Litigation finance is usually worked out on a multiple of the money involved in the case and the money that has to be invested in it. So if you're borrowing £1 million, you're quite likely to be paying out at the end of the day to the financier something like £3.5 million plus the million you put in. So we're talking there of £4.5 million coming out of the proceeds. And you can guess that a case has to be of substantial worth in order to make that work. Particularly when you think about settlement at the end of the day, is likely to be much less than the claim itself. So one needs to look at the likely proceeds and paint the picture in your investment document to those financiers. Having found your third-party funder who expresses willingness to invest, you need to have a look at the agreements that are going to be put to you by the financier. Familiarity with those agreements is really to be advised because they are long, complex documents and they do have some very exacting provisions within them to protect the financier. And they're written really for the benefit of the financier. And familiarity with those types of clauses is really important. Dealing with third-party funders is really a negotiation. You're negotiating about the price of the money, which will be dependent upon the likely outcome, the confidence that your lawyers are giving you, and also in relation to the proceeds. What is the likely outcome of the case? Also, there'll be negotiation about the terms, about the way in which you interact and your lawyers interact with the funder along the way and how final decisions are made. Third-party funders are not entitled in any way to interfere in the process of the litigation. That's between you and your lawyers. But at the end of the day, when it comes to any settlement, the share they take, the issues that arise from that will be important in reaching that settlement. Third-party funding has become an increasing aspect of modern litigation. We've seen many decisions in the courts in relation to elements of the agreement and elements of the package that you receive from the third-party funder. At Edwin Coe, we've been dealing with third-party funders for well over 20 years. We're familiar with the way in which they work. We're familiar with the whole market. We understand the agreements and the presentation made to third-party funders. We can advise you throughout that process.